Good day everyone. Good day ma'am. I am Ruben Hortilano the Bird from Group 4 and we're about to report the crimes against property Chapter 1 robbery in general from Article 293 up to 297. So ini nga chapter ron may duwa nga section which is the robbery with violence or intimidation of person and robbery by the use of force upon things. So natin yan na igtatagilan chapter 1. Article 293. Who are guilty of robbery. Any person who, with an intent to gain, shall take any personal property belonging to another by means of violence or intimidation of any person, or using force upon anything shall be guilty of robbery. So, itawo nga magamayada intention na manguha personal things, then the person will consider the guilty of robbery. Article 294. Robbery with violence against or intimidation of persons. Penalties. Any persons guilty of robbery with the use of violence against or intimidation of any person shall suffer, first, the penalty of reclusion perpetua to death, when by the reason or on occasion of the robbery the crime of homicide shall have been committed. Second, the penalty of reclusion temporal and the medium period to reclusion perpetua when the robbery shall have been accompanied by rape or intentional mutilation, or if by reason or an occasion of such robbery, any of the physical injuries penalized in subdivision 1 of Article 263 shall have been inflicted, provided, however, that when the robbery accompanied with rape is committed with the use of a deadly weapon or by the two or more persons, the penalty shall be reclusion perpetua to death, as amended by PD number 767. So third, the penalty of reclusion temporal, when by reason or on occasion of the robbery, any of the physical injuries penalized in subdivision 2, the article mentioned in the next preceding paragraph, shall have been inflicted. Fourth, the penalty of prison mayor in its maximum period reclusion temporal in its medium period. If the violence or intimidation employed in the commission of the robbery shall have been carried to a degree clearly necessary for the commission of the crime, or when the course of its execution, the offender shall have been inflicted upon any person not responsible for its commission, any of the physical injuries covered by subdivision 3 and 4 of said Article 23. Last is the penalty of prison. Correctional in its maximum period to prison mayor in its medium period in other cases, as amended by Republic Act number 18. Article 295. Robbery with physical injuries committed in an uninhabited place and by a band, or with the use of firearm on a street, road, or alley. If the offense mentioned in subdivision 3(4) of the next preceding article shall have been committed in uninhabited place or by a band, or by attacking a moving train, streetcar, moving vehicle, or airship, or by entering the passengers' apartments in a train or in a manner taking the passengers. Article 296. Definition of a bond and penalty incurred by the members. Therefore, when more than 3 armed malefactors take part in the commission of a robbery, it shall be deemed to have been committed by a band. When any of the arms used in the commission of the offense be unlicensed firearm, the penalty to be imposed upon the malefactors shall be the maximum of the corresponding penalty provided by law, without prejudice the criminal liability for illegal possession of such unlicensed firearms. Last is the Article 297, attempted and frustrated robbery committed under certain circumstances, when by reason or an occasion of an attempted or frustrated robbery, a homicide is committed. The person guilty of such offences shall be punished by reclusion temporal in its maximum period to reclusion perpetua, unless the homicide committed shall deserve a higher penalty under the provision of this code. Ito nga person nga guilty han robbery also committed an homicide. While robbering, iya ito kaharapon na penalties or punishment is reclusion temporal to reclusion perpetua. That's all of my report. Thank you.
Good day to all my classmates and also to our instructor. My report is Article 299 to 302, 304, 305 to 310. My name is Lacrosse James Patrick. Article 299, robbery with force upon things inhabited house, public building. Article 299, robbery in inhabited house or public building or edifice devoted to worship. Any armed person who shall commit robbery in inhabited house or public building or edifice devoted to religious worship shall be punished by reclusion temporal. The penalty if you are commit robbery with force upon things, the reclusion temporal is you have shall penalty from 12 years and 1 day or 20 years. The robbery be committed under any of the following circumstances: by breaking or doors, wardrobes, chest of any kind of lock or sell furniture or receptacles. Number 2, by taking such furnitures or objects away to be broken or forced upon outside the place of the robbery. Article 302. Article 302, robbery and inherited place or in a private building. Any robbery committed in an inhabited place or in a building other than those mentioned in first paragraph of Article 229. If the value of the property taken exceed 200 pesos, shall be punished by prison correctional in its medium and maximum periods, provided that any of the following circumstances is present. Number 1, if the entrance has been effective through any opening not intended for entrance or egress in any wall, if any wall, roof, floor, or outside door or window has been broken, if the entrance has been affected through the use of Polski or maling susi, picklocks, or other similar tools, if any doors, wardrobes, chest, or any sealed or closed furniture or receptacles has been broken, if any closed or sealed receptacles as mentioned in the preceding paragraph has been removed, even if the same be broken open elsewhere. Article 304, possession of picklocks or similar tools. Any person who shall without lawful cause have in his possession pickaxe or similar tools especially adapted to the commission of the crime of robbery shall be punished by arresto mayor in its maximum period to prison correctional in its minimum period. The same penalty shall be imposed upon any person who shall make such as tolls if offended be a locksmith. In this Article 304, possession of pickaxe or similar tools. If you commit this crime, you have punished by arresto mayor. It means you have penalties from 1 month and 1 day to 6 months. Article 305, false case or maling susi. Polski shall suffer the penalty of prison correctional in its medium and maximum period. Elements of illegal possession of pickaxe or similar tools. That the offender has in his possession pickaxe or similar tools. That such pickaxe or similar tools are especially adapted to the commission of robbery. That the offender does not have lawful cause for such possession. Article 306, brigandage. Article 306, brigandage. Brigandage is a crime committed by more than 3 armed persons who abandon robbers for the purpose of committing robbery in the highway or kidnapping person for the purpose of extortion or to obtain ransom or for any other purposes to be attempted by means of force and violence. Brigandage, it's like kidnapping. There is brigandage when there be at least 4 armed person. The brigandage, matatawag itong brigandage kung 4 or 3 pa itaas ang mga tao na may mga dalang mga armas. They form a band of robberies. Article 306, aiding and abetting a band of brigands. Any person knowingly and in any matter aiding, abetting or protecting a band of brigands as described in the next preceding articles or giving them information of the movement of the police or other based officer of the government or of the forces of the United States Army when the latter are acting in aid of the government or acquiring or receiving the property taken such as brigands shall be punished by prison correctional in its medium period to prison mayor in its medium period. Article 307, aiding and abetting a band of brigands. Kung itong article na 306, pag meron kayong makita o na rinarab na merong robbery in the highway, kailangan yung itawag sa mga otoridad sa ating pulisya para matulungan ito. Elements of brigands. That there is band of brigands. that the offender know the band to be a brigand, that the offender does any of the following acts: he in any matter aids, abets, or protects such as band of brigands, or he gives them information of movement of the police or other peace officer of the government, or he actually acquire or receive the property taken by such brigands. Mali pala ako. Ibig sabihin, tinutulungan ni Article 307, may isang tao na tumutulong sa mga nagra-robbery kung ano ang movement ng mga ating pulis. Article 308. Article 308. Theft. Theft is committed by any person who in to gain but without violence against or intimidation of person nor forced upon things shall take personal property or another without the letter of consent. Theft. Ito yung halimbawa snatching na hindi ginagamitan ng dahas or elements of theft, that there be taken of personal property, that said property belongs to another, that things be done without intent or gain, that the taking be done without the consent of owner, that the taking be accomplished without the use of violence against or intimidation of person or forced upon things. Example ito yung pagnanakaw sa mga tindahan na walang paalam. Article 309. Penalties for theft. Basic penalties in theft: the value of the things stolen and its some causes, the value of and also the nature of property taken, or the circumstances or causes that implayed the corporate to commit the crime. The last, Article 310. Under the provision of Article 310 Revised Penal Code, qualified theft is a crime or theft or taking without intent or gain or personal property of the owner without the letter of consent and committed by domestic servants, or with grave abuse of confidence, or if the property stolen is motor vehicle, mail matter, or large cattle, or consist of coconut taken from the premises of the plantation, or fish taken from fish pond or fishery. Ito may example na yung pagnanakaw ng motor at iba pa na walang paalam at hindi gumagamit ng dahas. If the property is taken on the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident, or civil disturbance, as amended by Republic Act 120. Thank you and God bless.
Good day, everyone. I am Junji De La Cruz from Group 4, and I am the one who assigned to report about the topics of 5 articles. So first is the Article 315. The crimes of estafa or swindling is punishable under Article 315 of the Revised Penal Code and there are different forms of committing it. This article may da siya sinisaring na three crimes of estafa or swindling. First, with unfaithfulness or abuse of confidence. Second, by means of false pretenses or fraudulent acts. And last, through fraudulent means. The unfaithfulness or abuse of confidence is by altering the substance, quantity, or quality of anything of value which the offender shall deliver by virtue of obligation to do so, even though such obligation be based on an immoral or illegal consideration. By misappropriating or converting to the prejudice or of another money, goods, or any other personal property received by offender in trust or on commission or for administration, even though such obligation be totally or partially guaranteed by a bond or by denying having received such money, goods, or other property. By taking undue advantage of signature of the offender party in blank, and by writing any document above such signature in blank to the prejudice of the offended party or any third person. Next, by means of false pretenses or fraudulent acts, by using fictitious name or falsely pretending to possess power, influence, qualification, property, credit, agency, business or imaginary transactions, or by means of other similar deceits. By altering the quality, fitness, or weight of anything pertaining to his art or business, by pretending to have bred any government employee without prejudice to the action for calumny which the offender party may deem proper to bring against the offender. In this case, the offender shall be punished by the maximum period of the penalty. Last, by postdating a check or issuing a check in payment of an obligation when the offender had no funds in the bank, failure of the drawer of the check to deposit the amount necessary to recover his check within three 3 days from receipt of notice from the bank, and or the pay or holder that said check has been dishonored for lack or insufficiency of funds shall be prima facie evidence of deceit's constitution, false pretense, or fraudulent acts. By obtaining any foods, refreshment, or accommodation at hotel, in restaurant, boarding house, lodging house, or apartment house, and the like, without paying, therefore, with intent to defraud the proprietor or manager thereof, or by obtaining credit at a hotel, in restaurant, boarding house, lodging house, or apartment house, by the use of any false pretenses, or by abandoning or surreptitiously removing any part of his baggage or from a hotel and restaurant, boarding house, lodging house, or apartment house. After obtaining credit for refreshment or accommodation therein without paying for his food, refreshment, or accommodation. True, true fraudulent means first by inducing another by means of deceit to sign any document. Second, by resorting to some fraudulent practice to ensure success in a gambling game. And last, by removing, concealing, or destroying in whole or in part any court record, office files, documents, or any other papers. In the next, elements of estafa in general. First, that the accused defrauded another by abuse of confidence or by means of deceit, and that damage or prejudice capable of pecuniary estimation is caused to the offended party or third person. Next, this is not an essential requisite of estafa with abuse of confidence. Deceit with intent to defraud is not an initial requisite in case wherein the money or other personal property has been voluntarily entrusted to the offender without wrongdoing on his part in obtaining or receiving it. Second element, the basis of penalty. It is necessary that the damage or prejudice be capable of pecuniary estimation because the amount of the damage or prejudice is the basis of the penalty for estafa. The second element, Article 318, other deceits. The penalty of aristo, mayor, and a fine of not less than the amount of the damage caused and not more than twice such amount shall be imposed upon any person who shall defraud or damage another by any other deceit not mentioned in the preceding articles of this chapter. The four elements that the offender takes advantage of the inexperience or emotion or feelings of a minor. Second, that he induced such minor, one, to assume an obligation, or two, to give release, or three, to execute a transfer of any property right. Third, that the consideration is one sum loan of money to credit or three other personal property. And last, that the transaction is to the detriment of such minor. Arson and other crimes involving destruction. Article 320. First, destructive arson, the penalty of resolution perpetua to death shall be imposed upon any person who shall burn. Second, one or more buildings or edifices consequent to one single and act burning or as a result of simultaneous burning, or committed on several or different occasions. Third, any building of public or private ownership devoted to the public in general or where people usually gather or congregate congregate for a definite purpose such as but not limited to official governmental function or business, private transaction, commerce, trade, workshop, meetings. Penalty for destructive arson resulting in death if as a consequence of the commission of any the acts penalized under Art 320, this should result the mandatory penalty of death shall be imposed. Article 320 as amended by Rape Act number 7659. However, pursuant to Rape Republic Act number 9346, which prohibited the imposition of the death penalty. The mandatory penalty of death for destructive arson where death ensues is now downgraded to reclusion perpetua with no eligibility for parole. Destructive arson distinguished from simple arson under PD number 1613. The nature of destructive arson is distinguished from simple arson by the degree of perversity or viciousness of the criminal offender. The acts committed under Article 320 of the Revised Penal Code constituting destructive arson are characterized as heinous crime for being grievous, odious, and hateful offenses, and which, by reason of their inherent of manifest weakness, viciousness, atrocity, and perversity, are repugnant and outrageous to the common standards and norms of decency and morality in a just, civilized, and ordered society. In other words, simple arson contemplates crimes with less significant social, economic, political, and national security implications than destructive arson. Malicious mischief. Article 327. Who are liable for malicious mischief? Any person who shall deliberately cause to the property of another any damage not falling within the terms of the next preceding chapter shall be guilty of malicious mischief. Elements of malicious mischief: that the offender deliberately cause damage the property of another. Second, that such act does not constitute arson or other crimes involving destruction. That the acts of damaging another's property be committed merely for the sake of damaging it. Article 320. Person exempt from criminal liability no criminal but only civil liability shall result from the commission of the crime of theft, swindling, or malicious mischief committed or caused mutually by the following persons. First, number one is possess as ascendants and descendants or relatives by affinity in the same line. Number two, the widow spouse with respect to the property which belonging to the deceased spouse before the same shall have passed into the possession of another. Number three, brothers and sisters and brothers-in-law and sisters-in-law, if living together, the exemption established by this article shall be not applicable to strangers participating in the commission of the crime. Crimes involved in exemption: number one, theft; number two, swindling, estafa; number three, malicious mischief. Person exempted from criminal liability: number one, spouses, as ascendants and descendants, or relatives by affinity in the same line. Number two, the widow of spouse to with respect to the property which belong to the deceased spouse before the same passed into the possession of another. Number three, brothers and sisters and brothers-in-law and sisters-in-law if living together. Crimes against chastity. What are the crimes against chastity? There are first, adultery in Article 333. Number two, concubinage, Article 334. Number three, acts of lasciviousness, Article 336. And number four, qualified seduction, Article 337. And number five, simple seduction, Article 338. And number six, acts of lasciviousness with the consent of the offended party, Article 339. Number 7, corruption of minors, Article 340. And number 8, white slaves trade, Article 341. In number 9, forcible abduction, Article 342. And last, consented abduction, Article 343. And that's all. Thank you.
My report is all about Chapter 1, Chapter 2, and Chapter 3. The first chapter is all about adultery and concubinage. Article 333, who are guilty of adultery. Adultery is committed by any married woman who shall have sexual intercourse with a man not her husband, and by the man who has carnal knowledge of her, knowing her to be married, even if the marriage is subsequently declared void. Adultery shall be punished by prison correctional in its medium and maximum period. If the person guilty of adultery committed this offense while being abandoned without justification by the offended spouse, the penalty is lower in degree than that provided in the next preceding paragraph shall be imposed. Article 334 is all about concubinage. Any husband who shall keep a mistress in the conjugal dwelling, or shall have sexual intercourse, under scandalous circumstances with a woman who is not his wife, or shall prohibit her in any other place, shall be punished by fration correctional at its minimum and medium periods. The concubine shall suffer the penalty or destierro. Chapter 2, Rape and Acts of Lasciviousness. Article 335, when and how rape is committed. Rape is committed by having carnal knowledge of a woman under of any of the following circumstances. Number 1, by using force or intimidation. Number 2, when the woman is deprived of reason or otherwise unconscious. And number 3, when the woman is under 12 years of age or is demented. The crime of rape shall be punished by reclusion perpetua. Whenever the crime of rape is committed with the use of a deadly weapon or by two or more persons, the penalty shall be reclusion perpetua to death. When by reason or on the occasion of the rape, the victim has become insane, the penalty shall be death. When the rape is attempted or frustrated and the homicide is committed by reason or on the occasion thereof, the penalty shall be likewise death. Article 336. Acts of lasciviousness. Any person who shall commit any act of lasciviousness upon other person of either sex under any of the circumstances mentioned in the preceding article shall be punished by fratio correctional. Chapter 3, Seduction, Corruption of Minors, and White Slave Trade. Article 337, Qualified Seduction. The seduction of virgin over 12 years and under 18 years of age, committed by any person in public authority, priest, house servant, domestic, guardian, teacher, or any person who, in any capital, shall be entrusted with the induction of custody of the woman seduced, shall be punished by fration correctional at its minimum and medium periods. The penalty next higher in degree shall be imposed upon any person who shall seduce his sister or this is done, whether or not she be a virgin or over 18 years of age. Under the provisions of this chapter, seduction is committed when the offender has carnal knowledge of any of the persons and under the circumstances described herein. Article 338, Simple Seduction. The seduction of a woman who is single or a widow of good reputation over 12 but under 18 years of age committed by means of this site shall be punished by Aristo Mayor. Article 339, Acts of Lasciviousness with consent of offended party. The penalty of Aristo Mayor shall be imposed to punish any other acts of lasciviousness committed by the same persons and under the same circumstances as those provided in Article 337 and 338. And the last article is 340, Corruption of Minors. Any person who shall promote or facilitate the prostitution or corruption of person under age of the satisfy the lust of another shall be punished by fration mayor of if the culprit is a public officer or employee, including those in government-owned or controlled corporation. He shall also suffer the penalty or temporary absolute disqualification.
Article 341, White Slave Trade. The penalty of prison correctional in its medium and maximum period shall be imposed upon any person who in any more or under any pretext shall engage in the business or shall profit by prostitution or shall enlist the service of woman for the purpose of prostitution. Acts penalize as white slave trade engaging in the business of prostitution profiting by prostitution, enlisting the service of woman for the purpose of prostitution. One of those above-mentioned acts is sufficient to constitute the offense, once it is proved that the accused enlisted the service of woman for the purpose of prostitution. He is criminally liable even if there is no proof that he shared in the profit. And even if there is no proof that he enlisted the service of woman for the purpose of prostitution, he would still be liable criminally if he shared in the income of the prostitute. So, ibig sabihin ng Article 341, ikaw ay napipinalize ng West Live Street na may parusahang prison correctional o 4 years to 2 months and 1 day to 6 years na pagkakakulong kapag napatunayan na ginawa mong negosyo ang mga kababaihan para ipasok sa prostitusyon. Yun ang element number 1 at ikaw ay kumikita ng dahil sa prostitution. Ibig sabihin ng number 2 at kumukuha or tumatanggap ka ng kababaihan para magtrabaho sa pamamagitan ng prostitusyon. Sa pamamagitan ng tatlong ito, pwedeng mapinalize ang isang tao na white slave trade. Article 342. Abduction. By abduction is meant the taking away a woman from her house or the place where she may be for the purpose of carrying her to another place with intent to marry or to corrupt her. So, ibig sabihin po ay kapag kinuha or inilayo ang isang babae mula sa kanyang tahanan o dalhin sa ibang lugar para gawing isang asawa, ang tawag po doon ay abduction. At ang abduction ay may 2 kinds. Una, forcible abduction at pangalawa ay consented abduction. So, forcible abduction, the abduction of any woman against her will and with lewd design shall be punished by reclusion temporal. The same penalty shall be imposed in every case if the female abducted be under 12 years of age. Elements of forcible abduction: that the person abducted is any woman regardless of her age, civil status, or reputation. That the abduction is against her will. That the abduction is with lewd designs. So, alam na po natin ang kahulugan ng abduction dahil sinabi ko na. So, forcible abduction, ito ay ang labag sa kalooban ng isang babae o hindi niya gusto na. Kaya nga forcible dahil sa pilitan lamang. At kapag siya ay binastos, ito ay may kaparusahang reclusion temporal of katumbas ng 12 years and 1 dito 20 years na pagkakakulong. Article 343. Consented abduction. The abduction of a virgin over 12 and under 18 years of age carried out with her consent and with lewd designs shall be punished by the penalty of prison correctional in its minimum and medium periods. Elements: number 1, that the offended party must be a virgin, that she must be over 12 and under 18 years of age, that the taking away of the offended party must be with her consent after solicitation or cajolery from the offender, that the taking away of the offended party must be lewd designs. So, ibig sabihin po nito, ito ay abduction na kung saan ang isang babae ay isang virgin at lampas 12 or under 18 years of age. Yun po ay element number 1 and 2. At ito ay may pahintulot or consent mula sa isang babae na dalhin siya sa isang lugar, ilayo sa kanila at lewd design o pambabastos. Ito po ay consented abduction na may kaparusahang prison correctional of 4 years to 2 months and 1 day to 6 years na pagkakakulong. Chapter 5. Provisions relative to the preceding chapter of Title 11. Article 344. Prosecution of the crimes of adultery, concubinage, seduction, abduction, rape, and acts of lascivious useness. The crime of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. The offended party cannot institute criminal prosecution without including both the guilty parties if they are both alive, nor in any case if he shall have consented or pardoned the offenders. The offenses of seduction, abduction, rape, or acts of lasciviousness shall not be prosecuted except upon a complaint filed by the offended party of their parents, grandparents, or guardians, nor any case if the offender has been expressly pardoned by the above-named persons, as the case may be. Prosecution of adultery, concubinage, seduction, abduction, rape, and acts of lasciviousness. Adultery and concubinage must be prosecuted upon complaint signed by the offended spouse. Seduction, abduction, rape, or acts of lasciviousness must be prosecuted upon complaint signed by a offended party, by her parents, grandparents, or the guardians in the order in which they are named above. Ibig sabihin po ng article na to, ang adultery at concubinage ay applicable lamang na mag-file ng complaint ay ang asawa or spouse. At sa case naman ng seduction, abductions, acts of lasciviousness, at rape ay applicable lamang na mag-file ng complaint ay ang kanyang pamilya, magulang niya, lolo at lola, at kahit sinong guardian niya. Article 345. Civil liability of persons guilty of crimes against chastity. Persons guilty of rape, seduction, or abduction shall also be sentenced. 1. To indemnify the offended woman to acknowledge the offspring unless the law should prevent him from so doing. In every case, to support the offspring. The alterer and the concubine in the case provided for in Articles 333 and 334 may be also sentenced in the same proceeding or in a separate civil proceeding to indemnify for damage caused the offended spouse. Civil liability of persons guilty of rape, seduction, or abduction. To indemnify the offended woman to acknowledge the offspring unless the law should prevent him from doing so. In every case, to support the offspring. So, ibig sabihin po ng Article 345, ikaw ay may civil liability o ang isang taong guilty ng rape, seduction, or abduction ay kinakailangan mong magbayad ng danyos sa babaeng biktima at kailangan mong tanggapin o kilalanin bilang iyong anak ang isinilang ng iyong nabiktimang babae at ikaw ay magbigay ng financial support o sustento sa anak ng iyong nabiktima. Article 346. Liability of ascendants, guardians, teachers, or other persons entrusted with the custody of the offended party. The ascendants, guardians, curators, teachers, and any person who, by abuse of authority or confidential relationship, shall cooperate as accomplices in the perpetration of the crimes embraced in chapters 2nd, 3rd, and 4th of this title, shall be punished as principals. Teachers or other person in any other capacity entrusted with the education and guidance of youth shall also suffer the penalty of temporary special disqualification in its maximum period to perpetual special disqualification. Any person falling within the term of this article and any person guilty of corruption of minors for the benefits of another shall be punished by special disqualification from filing the office of guardian. Persons who cooperate as accomplices but are punished as principal in rape, seduction, abduction, etc. 1. Ascendants, guardians, curators, teachers, and any other person who cooperate as accomplices with abuse of authority or confidential relationships. Ibig sabihin po nitong Article 346 ay ang ascendants, guardians, teachers, at ang ibang tao na nakipag-cooperate as accomplice or kasabwat with abuse of authority or confidential relationship pwedeng mapunished as principal or liable for the crime of rape, act of lasciviousness, qualified seduction, simple seduction, and etc. At sila ay magsasuffer ng penalty temporary special disqualification in its maximum period to perpetual special disqualification. Article 347. Simulation of birth, substitution of one child for another, and concealment or abandonment of a legitimate child. The simulation of birth and the substitution of one child for another shall be punished by prison mayor and a fine of not exceeding 1,000 pesos. The same penalty shall imposed upon any person who shall conceal or abandon any legitimate child with intent to cause such child to lose its civil status. Any physician or surgeon or public officer who in violation of the duties of profession or office shall cooperate in the execution of any of the crimes mentioned in the two next preceding paragraphs shall suffer the penalties therein prescribed and also the penalty of temporary special disqualification. Acts punished under Article 347. Simulation of birth, substitution of one child for another, concealing or abandoning any legitimate child with intent to cause such child to lose its civil status. Ibig sabihin po, ikaw ay mapaparusahan ng prison mayor or 6 years and 1 day to 12 years na pagkakakulong at magbabayad ng fine or penalidad ng hindi mag-i-exceed ng 1,000 pesos kapag pinakaalaman ang isang sanggol para hindi mapunta sa kanyang biological mother o simulation of birth at ipagpalit sa mga sanggol at panghuli ay ang pagtago o pag-iwan ng isang lehitimong anak para mawala ang kanyang civil status.
Upon any person who shall contract a second or subsequent marriage before the former marriage has been legally dissolved or before the absent spouse has been declared presumptively dead by means of a judgment rendered in the proper proceedings. In explanation, in this article, it explained the bigamy is punishable under the Article 349 of the Revised Penal Code. It means that bigamy is the act of entering into a marriage with the one person while is still legally married to another. So if one person accused for the crime of bigamy, prison mayor shall be sentenced to imprisonment within the range of 6 years and 1 day to 12 years. So elements of bigamy: that the offender has been legally married, that the marriage has not been legally dissolved, or in cases or spouse absent and absent spouse could not yet be presumed dead according to the civil code, that he contract second or subsequent marriage, that the second or subsequent marriage has all the essential requires for validity. Causes which produce the legal dissolution of this first marriage: first, death of one of the contracting parties; second, judicial declaration annulling a void marriage and judicial decree annulling a voidable marriage. So, in my explanation, those three causes which may produce the legal dissolution of the first marriage. So, the bigamy case does not extinguish the crime because when accused married the second spouse, the first marriage was still subsisting. Bigamy is not a private crime. In the crime of bigamy, it is immaterial whether it is the first or the second wife who initiate the action, for it is a public offense which can be announced not only by the person effective thereby, but even by a civic spirit citizen who might come to know the same. In my explanation, yes, bigamy is not a private crime, although bigamy is a public offense and a crime against status. The crime of bigamy is committed by any person who shall contract a second or subsequent marriage. Article 353, Definition of Libel. A libel is a public and malicious imputation of a crime or a vice or defect, real, imaginary, Oragnac, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural judicial person, or to blacken the memory of one who is dead. So defamation. Defamation, which include libel, slander, means the offense of injuring a person's character, fame, or reputation through false and malicious statements. It is that which tends to injure reputation or to diminish the esteem, respect, goodwill, confidence in the plaintiff, or to excite derogatory feelings or opinion about plaintiff. So, in my explanation, defamation meaning it is the oral or written communication of a false statement about another that unjustly harm their reputation and usually constitute a crime. Although in several countries, true statement can also be considered defamation. So, elements of defamation. Elements of defamation. First, that there must be the imputation of a crime, or of a vice, defect, real, imaginary, or an act, omission, status, circumstance. Second, that the imputation must be made publicly. The third, that must be malicious. That the imputation must be directed to a natural or juridical person or one who is dead. 5. That the imputation must be tend to cause the dishonor, discredit, or contempt of one of the person defamed. My explanation. Defamation 1. Defamation are finalized under the revised penal code. So in order to successfully lodge a case or slander, these 5 elements of defamation must be proven. If the imputation is verbally made, then it is considered as slander. However, if the imputation is made through writing, printing, lithography, radio, and other similar means, it is punishable as libel. So, Article 355, libel by means of writing similar means. A libel may be committed by means of writing, printing, lithography, engraving, radio, phonograph, painting, theatrical exhibition.
Article 361. Proof of the truth. In every criminal prosecution for libel, the truth may be given in evidence to the court, and if it appears that the matter charged as libellous is true, and moreover that it was published with good motives and for justifiable ends, the defendant should be acquitted. The proof of the truth of an imputation of an act or omission not constituting a crime shall not be admitted, unless the imputation shall have been made against the government employees with respect to facts related to the discharge of their duties. In such cases, if the defendant proves the truth of the imputation made by him, he should be acquitted. And now let's proceed to the chapter 2, which is incriminatory machinations. Article 363. Incriminating innocent person. Any person who, by an act not constituting perjury, shall directly incriminate or impute to an innocent person to commission of a crime shall be punished by arresto minor. Article 364. Intriguing against honor. The penalty of arresto or fine not exceeding 200 pesos should be imposed for any intrigue which has for its principal purpose to blemish the honor or reputation of a person. How is intriguing against honor committed? It is committed by any person who shall make any intrigue which has for its principal purpose to blemish the honor or reputation of another person. Now, let's proceed to the Article 365, which is imprudence and negligence. Any person who, by reckless imprudence, should commit any act which, had it been intentional, would constitute a grave felony, shall suffer the penalty of arresto mayor in its maximum period, to prison correctional in its medium period, if it would have constituted a less grave felony. The penalty of arresto mayor in its maximum and medium period shall be imposed if it would have constituted a light felony. The penalty of arresto minor is its maximum period should be imposed. So technically, the reckless imprudence generally defined by our penal law consents the voluntarily but without malice doing a failing to do an act from which material damage result by reason of inexcusable lack of precaution on the part of the person performing or failing to perform such act, taking into consideration his employment or occupation, degree of intelligence, physical condition, and other circumstances regarding persons, time, and place. The reckless imprudence under the Article 365 of the Revised Penal Code, ayon sa batas, ang reckless imprudence ay kadalasan na ikakabit sa kawalan ng pag-iingat, sa paggawa o hindi paggawa ng mga kilos, ngunit ang kawalan ng ingat o reckless imprudence per se ay hindi isang culpable felony. Magiging culpable felony lamang ito kung nagre-resulta ito ng isang pangyayari na maituturing na grave, less grave o light felony sa RPC. Halimbawa, kung ang reckless imprudence ay nagresulta sa pagkamatay ng tao o homicide, isa itong grave felony. Nagiging culpable felony na ito na may karampatang parusa na Article 365 ng RPC. That's all. Thank you.